So thank you so much for that kind introduction. And I've already told Joe Grunfest, who invited me here, that he does not get rebuttal time. So, I am mostly interested in hearing your thoughts and responding to any questions or comments you have. That's really what is important to me. Rachel Unger, who brought me over here a few minutes ago, said, "What are you expecting from the students?" And I said, I expect, because it's Stanford Law School, that they will be brilliant, provocative, and interesting. And if they're not, I'm going to report it to U.S. News and World Report. So, but Joe asked me to say a few words, not on the subject, the advertised subject about Wall Street, though I'm very happy to answer any of your questions about that subject, but on a different subject that he thought was kind of timely, which was the role of the judiciary in checks and balances. I don't know why he thought that was au courant, but I will say a few things about that. So our Constitution obviously sets up a system where the three branches of government serve to some extent as checks on the other branches of government, but I think it's much too facile to just describe it in that broad brush way. Unlike the other two branches, the judiciary is not intended to be a policy-making body. We're not elected by anyone. We don't respond to the electorate. We don't have terms. We have life tenure. And therefore, I think most judges feel, and I think it's implicit in the constitutional makeup, that judges are not intended to be policymakers. What they are intended to be is people who enforce the laws, and particularly the Constitution. So, for example, you could say that in the early years of the New Deal, the Supreme Court, from a superficial standpoint, was acting as a check on what was perceived as the excesses of the New Deal. But I think that would be not a fair reading of history. A majority of that Supreme Court was really exercising a policy direction, a conservative policy direction, and they declared many of the New Deal laws unconstitutional on grounds that, in hindsight, really won't bear scrutiny. And so that got them into trouble, rightly got them into trouble, and that's the kind of check, if you will, that is not appropriate for the courts. However, there's been a different development over the years that is, to my mind, more troublesome, which is that the Supreme Court has abdicated enforcing the Constitution in many areas where the executive operates. And they give various terms to these kinds of abdications. There are national security matters, political questions, matters entrusted to the expertise of administrative agencies. There are a variety of ways in which they duck their responsibility, but it's not been, in my view, consistent with what the Constitution contemplated. I'll give two famous examples, but although they're somewhat sui generis. During the Civil War, Abraham Lincoln did away with habeas corpus for the duration of the war. The Constitution is crystal clear that only Congress can do that, but he decided he wasn't going to get it through Congress, and so he just did it unilaterally. A case went up challenging that to the Supreme Court. The Supreme Court purposely stalled until after the Civil War was over, and then they said, Lincoln should not have done that, it was unconstitutional, you naughty boy, but of course it had no effect because the war was over. Okay. maybe we'll cut him some slack because he was our greatest president and it was the Civil War. But let's go to a more recent example, which is, in my view, among the 2 or 3 worst decisions ever rendered by the Supreme Court, which is Korematsu. So this was during World War II. And a general had decided to issue an order under national security, rounding up and putting in internment camps all American citizens of Japanese descent. And when you think about it, it's so mind-boggling. Here we were fighting Hitler and talking about how he was sending people to concentration camps, and lo and behold, in this respect, we were doing it too. It came up to the Supreme Court, which in those days was very liberal, and nevertheless, 6-3, in an opinion, if I recall correctly, it was either by Douglas or Black, 2 of the great liberal justices, said, oh, well, it's national security and we've got to defer to national security and we don't really enter into that fray, even when people's most basic constitutional rights are at stake. So there's a long history, of which those are just 2 extreme examples, of the courts ducking their responsibility in the check and balance situation. Now, there has been some movement, more positive movement, in recent years. And the case that I would particularly point to is Boumediene versus Bush, which was a 2008 decision of the Supreme Court, very conservative Supreme Court. Nevertheless, the Supreme Court, over vehement government executive opposition, said that the detainees in Guantanamo had a right to habeas corpus, had a right to have their situation reviewed by a federal court. Even though they weren't citizens, even though Guantanamo was not part of mainland, if you will, U.S., and even though the government took the position that the Supreme Court didn't even have jurisdiction, it was purely a matter of national security and they should get lost. And the court, to its, my view, very great credit, said no, we will enforce the Constitution even in this situation. Now, the bad news is in many of the follow-up cases to that involving specific detainees, the lower courts ducked and did not do what they arguably should have done under the aegis of Boumediene. But still, it gives me some hope. I had, just by way of digression, a little Guantanamo case. The Associated Press back in around 2005 brought an action before me asking for the names of the detainees in Guantanamo, which they had all been held incommunicado up till then. And the government took the position that I did not have jurisdiction and it was a matter of national security. And in any event, assuming arguendo that I had jurisdiction, what they were doing was protecting the privacy rights of the detainees, which I thought was only a lawyer could like that kind of argument. But I held the other way, and eventually all the names were released. But it shows you the lengths that the government will go to if there's not a meaningful judicial check. So what will happen in the future? I have no crystal ball, but I am slightly more optimistic, cautiously optimistic, that than I would have been before Boumediene, that the courts will indeed step up to the plate and serve as a check to any excesses that are unconstitutional in nature. So those are just some thoughts that I wanted to share with you. Now I'm open to questions, and they can be about Wall Street or anything else, and I'm very happy to answer your questions. Yes, sir.
So do you think that there is a revolving door door problem, basically, between white-collar defense practices and the Department of Justice? And
No.
Not to the extent that you believe corporate settlements are too lenient. Why? Why do you think the main reason?
So those two good questions, and so as to the revolving door, and you have to look at this differently in different agencies. So there may be a revolving door problem in some agencies, but in the Department of Justice, U.S. Attorney's Office, and so forth, there is not, in my view, because the way you get hired by the big law firms is to make your name as a successful prosecutor. So if anything, the incentives cut the other way. And you'll see someone brings a big prosecution and wins the case against some high-level company or some high prominent individual, and 2 weeks later he is grabbed for a partnership at some very prestigious firm. So I don't think there's a revolving door problem. Also, most of the people are young. Their bosses are not quite so young, but so the juices are flowing, and a lot of things that would counter the kinds of considerations that's involved in the revolving door don't operate to the same extent. Nevertheless, I think the Department of Justice has completely blown it over the last 10 years and more in failing to prosecute high-level individuals and instead going after companies. Why has that happened? It hasn't been, in my view, because of the revolving door. There are a number of reasons for it, but I think the most basic reason is a combination of resource allocation and good politics, or what is perceived as good politics, though it may not be. And here's what I mean by that. Back in the day when I was chief of the Securities Fraud Unit in the U.S. Attorney's Office, it was uniform policy throughout the 60s, 70s, 80s, and 90s that you never went after companies. You sometimes did civilly. The SEC had a different reason for going after it, but criminally you didn't, because the object was to find out who had actually committed the crime. Obviously, a company is not a robot. And there were people who made the decision to commit the crime, and other people who knowingly winked at it and allowed it to happen. And very often that reaches up to very high levels. So we, the prosecutors, not just in my unit, but throughout the Department of Justice, considered it a failure if we couldn't identify who the people were who had committed the crimes. That changed beginning around 1996 or so, which that was the date of the first deferred prosecution agreement. But it became more intense after the financial crisis. And to make one of those cases, as I well remember from back when I was a prosecutor, against a high-level individual, takes 2, 3, 4 years. Why? Because you have to, it's not significantly different from how you prosecute narcotics cases or mafia cases. You start with the low level, the guy who actually pulled the trigger, or in the financial kind of crisis wrote the false entry or whatever, and you flip that person, and then you slowly work your way up, being very mindful that because the flip person has a temptation to finger people above, you have to be very careful that you can corroborate that person and that it's not just something that the guy's making up. That takes a long time, and it doesn't always pan out. So you might have a couple of prosecutors, and the SEC typically will lend folks to help out on those kind of cases. So you might have 4 or 5 bodies, which is a lot in this area, working for 3 or 4 years, and sometimes they would come up with nothing. And sometimes they would come up with terrific cases, like the head of Enron, like the head of WorldCom, like the Michael Milken in the junk bond cases, like in the S&L crisis, 800 people all the way up to Mr. Keating, who is the #1 progenitor of that fraud, and so forth. But it took a long time. If you go after a corporation, and in the introduction there was something about enemy of business or something of big business. That's not true. I'm an American. How can I not love big business? But it's good or bad. A company cannot be at war with the government forever. They can be at war for a short time, but that's about it. So they have to come to terms. So if you have a prosecution started against a company and you have any meaningful evidence at all, because under federal law, the crimes of even the lowest level person are imputed all the way up to the company, respondeat superior. So the company's dead. They're going to have to agree to some sort of settlement. And so it's an easy case to make. And if the public doesn't seem satisfied, you up the fine. So instead of millions, it becomes billions. And you announce it with great fanfare. And you go on to the next case. And so my view is that the most basic reason why they've gone after companies rather than individuals is because it's so easy to make those cases and so hard to make the cases against the individuals. Now, if someone from central justice from the Obama administration were here, and those are, well-intentioned people, and I disagree with a lot of their calls, but I have no doubt about their good faith, they would be making the argument that, if you go after individuals, 10 years later, some other individual's going to commit a crime. The thing is you have to change, quote, corporate culture, which I think is a very misused term and has different meanings in different contexts and maybe is kind of fuzzy to begin with. And so the way to do that is go after the corporation, not just a matter of the fines, but also you impose compliance requirements. Sometimes you appoint a monitor, and you change their whole way of doing business. So the great study of this is by Brandon Garrett, who is a professor at University of Virginia Law School, which is not Stanford, but chopped liver. He studied every corporate prosecution, including deferred prosecutions and so-called non-prosecution agreements from 2000 to 2014. And he concluded that the recidivism rate was, I don't remember the exact statistic, but roughly 1/3. So that's strong that the change in corporate culture was not occurring. So even if the theory was right, which I doubt, in practice it wasn't working out. And there are a lot of downsides to going after a corporation. Who's paying the fine? It's the shareholders. They didn't commit any crimes. Now, they may have been beneficiaries, and that's why a civil suit against a corporation after a fraud might be appropriate. The SEC could bring an action saying, you got money, the shareholders you weren't entitled to, you have to give it back, and we'll put it into a fair fund and distribute it to people who were victimized or whatever. But this is a criminal prosecution. They didn't commit a crime, and yet they're paying the main penalty. If the penalty is really high, the company will lay off low-level workers. I had the WorldCom case, the SEC part of that case, and if we had followed what some people wanted to do in that case and killed the company, there would have been 60,000 workers who would be out of a job. And it made, to me, much more sense to try to preserve the company but get rid of the bad individuals. And all the top people there went to prison. But that was before this whole approach that I'm talking about really came into full force. I think corporate prosecutions are a mixed bag at best based on a faulty theory, and I can't help but think that the real reason that they are preferred over going after individuals is it's a lot less work. Long-winded answer to your question. Yes.
So one of the things that I glean from your answer is that notwithstanding the politics, the proof just may not be there, or it's very difficult to prove to make the case. So I wonder, do you think that it's an issue, there's an issue of prosecutors not having the right criminal statutes to bring these cases in the 21st century?
No, most of the 19th century statutes are written in very broad terms. They're really much better than the 20th century statutes, let alone the 21st century statutes that you might contemplate. The most obvious one is the mail fraud statutes, a one-sentence statute. It basically says if you commit a fraud, you go to jail. So I don't think the problem is legislation. On the regulatory side, there's an important debate about how much regulation is or is not needed. But on the criminal side, I don't think that's an issue. In theory, the government is not supposed to bring any criminal prosecution against a company unless they have at least one individual that they can point to who is fully prosecutable for the same crime. Again, respondeat superior. If it's a low-level individual, that's another problem. Why the hell are you going after the whole company for some low-level individual? If instead it's a high-level individual, why the hell are you not prosecuting him and just going after the company? Now, yes, those are difficult cases to make, but they were, as in all those examples I gave earlier, they can be made. An important aspect of that is the doctrine of willful blindness, which is a judge-made doctrine, but one that's been fully endorsed repeatedly by the Supreme Court, which basically says if you're a high-level executive and there are all sorts of weird things going on, and you basically say, oh, well, Joe, you take care of that, I don't want to know about it, a jury can infer that you're saying that because you know darn well misconduct is occurring, and you just want to blind yourself to it. And the law says that that is a full substitute for criminal intent. So that's a lot of the cases against high-level executives are made that way. Yes, sir.
I've read an account of sort of the dearth of individual prosecutions that laid the blame on the fact that offices, after years of using deferred prosecution agreements as the normal practice, had actually lost the institutional knowledge about how to bring these complex, years-long cases. And I was wondering what you thought of that argument, that there just aren't enough prosecutors who have experience doing what you did.
Well,
they have to, they're stuck.
There's some truth to that, but I wouldn't say that that's the major factor, but I think it may be a contributing factor because these are cases that cannot be made by any junior line prosecutor. In the U.S. Attorney's Office for the Southern District of New York, the most senior people were the people who were put in the Securities Fraud unit. And they were people who had developed through smaller cases in other units a feel for accounting, a feel for some of the kinds of issues that would come up that wouldn't come up in a narcotics case or a mafia case. Having said that, the central technique is not different from what prosecutors do use even today in those other kinds of contexts. It is not rocket science at all. It's basically you start with the junior guy and you flip him and you move on up. And that junior guy will educate you often to the, not only the particulars of the business, but where the bodies are buried, so to speak. Now, as I said before, you have to be very careful because once you cut a deal with that kind of guy, he's got a big motive to lie because it's to his benefit to finger other people. So that's one of the reasons it takes so long, but it's not lack of expertise. Having said that, the Obama administration, and I'm a liberal Democrat and all like that, but the Obama administration, for what I think was largely political reasons, right before the second presidential election of the Obama years, created a task force that was supposed to look into prosecution of financial crimes, not just corporate prosecution, but individual prosecutions. And the reality, and I've talked to a number of people who were on that task force, it really was a committee whose sole purpose was to siphon off cases to different U.S. attorney's office. So they weren't all concentrated in one or two U.S. attorney's office. A factor that you should be aware of, though I don't want to overemphasize, there's a constant tension between the Southern District of New York and Central Justice, because the Southern District of New York is the natural place, because of the financial markets, to bring this kind of stuff. Central Justice hears it from all the other U.S. attorneys, why aren't you sending the cases to us? And so that kind of tension goes on. So this committee was supposed to parcel out, and a lot of the cases they parceled out to U.S. attorneys' offices that had no experience whatsoever in this kind of case. So the poster child of that is Angelo Mazzillo. So countrywide, and I can speak about this only because the statute of limitations says run, the countrywide was the single largest broker of mortgages used to fund mortgage-backed securities in the United States. Sold. It's now a branch of Bank of America, but it was an independent company in those days, and it sold to Fannie Mae and Freddie Mac and so forth in billions of dollars. And as a case that was before me, a civil case established to the satisfaction of the jury, it was portraying its mortgages as much better than they were, a form of lie, easily prosecutable under the mail fraud statute. The Mr. Mazzillo, the guy at the top, was sued by the SEC in 2009. And in their complaint, they quoted his emails. Emails, by the way, if any of you want to be a crook, avoid emails. That's where the dirt is buried. So in his emails, he described what he was portraying to the people he was selling to as great mortgages. He described them as, quote, poison and, quote, toxic. So, that would be a pretty good start to a criminal case. He settled with the SEC, and for many millions of dollars, actually by SEC standards at that time, a fairly large individual settlement, but without admitting or denying. That's the SEC approach, which has its own problems. So none of it was collateral estoppel. But, the combination of the charges from the SEC and the emails and so forth at least suggested there was some serious evidence there. It was referred originally to the U.S. Attorney's Office in Sacramento. Now, I have nothing against Sacramento. I understand that California politicians who reside there are a lot more honest than New York politicians, but that's saying so little. That was an office that had no experience, zero, in prosecuting sophisticated financial cases. And 2 years later, I was sent to Sacramento. The nominal reason was because the company was headquartered nearby, but it was a choice made by these kinds of considerations because it could have been prosecuted in New York. It could have been prosecuted in many different places that had much more sophistication in this area. 2 years later, the U.S. attorney there announced in one sentence, we've decided not to criminally prosecute Mr. Mazzillo. Nothing more has ever surfaced as to why that was. And I don't know whether he's guilty or innocent. I'm not here to I'm just saying it was a funny place to send that case. or funny is the wrong word, that's more sinister sounding. It was not, from an expertise standpoint, which was your question, the appropriate places in that case. Other questions? Yes, sir.
Just to go back in history a little bit, where you did have successful prosecution of individuals back in the Enron days, and Wall Street certainly, was prosecuted for that. Yet the result, at least in terms of Wall Street executives, seemed to be, reversed on remand. The government didn't prosecute again. How much of that was because the Southern District didn't handle it? How much of that was overzealousness? How much of that was just, as you said, it was just unrewarding the prosecutor?
So there are two cases, I'll elaborate a little broader on the very question you're raising. There are two cases that I think were overrid by central justice and were another reason they weren't as aggressive as one would have expected. One was the Arthur Andersen case, which was part of the Enron case, where the company basically was killed by the indictment because the nature of that industry is you choose from among maybe in those days 8 firms, now it's even less, and why are you going to choose one that's under indictment when you can choose one that's not? That prosecution was ultimately reversed, although not on the merits, not on the factual merits, but on problems with the charge. But it was too late. So that was one. That was a big incentive to things like deferred prosecutions. On the individual side, the only case brought against high-level people, and they weren't even that high, but they're moderately high, in connection with the financial crisis, was the Bear Stearns case in the Eastern District of New York, and that occurred again in 2009, fairly early on, and 3 people were accused of having engaged in fraud in connection with the mortgage sales by Bear Stearns, a big brokerage firm, and they were all acquitted. Cases, these are not easy cases. You're going to lose some cases. I don't know it's true. Some people have told me it was a poorly tried case. Maybe it was, maybe it wasn't. But, just in the course of things, not every individual prosecution is going to be successful. But what I've been repeatedly told by people who were in central justice at the time was that central justice took that to heart too much and thought, oh, well, that was an embarrassment and we've got to avoid that kind of thing. And of course, as I said earlier, it's so easy to go after a company. You know you're going to win. You know you're going to have a settlement because the company really can't fight you forever. And the reason they can't fight you forever is shown by Arthur Andersen, the one exception where they did fight and they went out of business, even though they won in some sense in the Supreme Court. So. Yes, sir.
As far as judicial review of corporate settlements, what do you see as being the most viable mechanism for that, if anything? And specifically, the Crime Victims' Rights Act was recently amended to confer a right to timely notice of a deferred prosecution or settlement agreement. And you know how that might end up interacting with judicial review of corporate settlements.
So basically, most judges give the most trivial review to settlements of all kind. And the reason is it's a case off their docket. We're all busy, and very few of us have the luxury to come out to Stanford for a week. Getting a case off your docket is getting a case off your docket, and if the government is one of the parties, then the assumption is, okay, it must be okay, or the government wouldn't have entered into this settlement. So, again, in the book Too Big to Jail by Brandon Garrett, he points out how superficial the review of most deferred prosecutions has been, let alone other kinds of settlements. And a non-prosecution agreement is not even subject to judicial review. But I tried in 2 SEC settlements to give a more searching review, one involving Bank of America, one involving Citigroup. And I got away with it on Bank of America, and I said the settlement was no good, and they had to come back and give me a much better settlement, which I then approved. And not having learned the lesson of history that a small victory doesn't guarantee a big one, I said that the Citigroup settlement with SEC was no good. And I got into it in great detail and wrote a long opinion and all that kind of stuff. And the Second Circuit slapped me down in no uncertain terms and said the heavy deference should be given to the government, and short of something like collusion or something really extreme like that, it's not for the court to determine whether the settlement is, as I had held, reasonable or unreasonable, adequate or inadequate, fair or unfair. None of those standards apply except in very, very modest ways now, at least in the Second Circuit. So that's where the law is. So there's not going to be much review, regardless of, Congress has not changed that. But although that could be a welcome law, in my view, that would give courts more of a duty to independently review these settlements, but that doesn't exist now. Having said that, some judges have become a little bit more energetic in asking questions about settlements. Nothing precludes that. And some settlements have been remade in ways that more reflect the public interest because of the questions raised by those judges. So it's not totally a dead issue, but it's not one that inspires a great deal of optimism. Other questions? Yes, sir.
If you were to look at legislation,
I never turn to the right. So.
If you were to look at like a specific juncture in time, and like a specific case, and all the law, all the precedent was exactly the same, but the sentiment of the people was different, like the culture was different. What role do you think that can play in the outcome of a lawsuit?
Well, there's an old saying that the Supreme Court follows the election returns. It's not, judges are not completely oblivious to changes in public opinion. But I think few of them pay that much attention to it, and I don't think they should. So what is maybe among the most core jobs of a federal judge? And why are we given lifetime tenure, and why are we given independence? It's to protect the unpopular, to protect minorities, to protect people who espouse very unpopular views, and so forth. And if we paid attention to public opinion in those kind of cases, we would not be doing our core duty. So it's a little bit different from what you're hypothesizing, but I think it plays a role, but all judges are a little cautious about that.
So, Your Honor, not by way of reply, but by way of amplification,
Yes.
if I may?
Yeah. I knew I couldn't keep him quiet.
So these changes in society manifest themselves in the judicial system in ways other than what Judge Rakoff writes in opinion. There's tremendous discretion of the prosecutor as to which prosecution to bring. Social mores, social forces, and the like will change prosecutorial discretion. So we're no longer going to be bringing cases for small amounts of marijuana, right? That's, society has changed, and that's more the change in some jurisdictions than others. What a jury will convict on, right, will also change as a result of the fact that society says, really, you ate up our time on this kind of a drug case? You know, not guilty, right? So Judge Rakoff sits in a much larger equilibrium system, and although Judge Rakoff may not and perhaps should not change according to the mores, you know, like a leaf blowing in the wind, other parts of the system are highly sensitive.
So that's a terrific point, and I agree with it. Yeah, A minus. But I would make one little modification to that, which is that often changes in public opinion, if you will, come a generation later than they should. And I'll give you a specific example. So Professor Grunfest was referring to prosecutorial discretion. So the criminal justice system in the United States is 95% at least in the hands of the prosecutor. The statistics are that only 3% of all criminal cases go to trial. All the others are settled in plea bargains, which are made in the prosecutor's office in a secret negotiation, secret in the sense that no one thinks it should be recorded, and where the prosecutor holds most of the marbles. And there's tremendous variation among prosecutors on just the kind of things that Professor Grunfest was referring to, whether this kind of case is an appropriate exercise of prosecutor power and so forth, or what the sentence should be, and it varies in different parts of the country. But what has happened in the United States is the following. There was a big rise in crime beginning in the late 60s. And a lot of laws were passed that had draconian penalties, mandatory minimums, guidelines that were originally mandatory as well, and all sorts of penalties that were ratcheted up. And the result was that no one, including some innocent people, could not take the risk of going to trial. They had to negotiate with the prosecutor to get a plea bargain that would have them less exposed, so they would face a lesser sentence. And that whole view was very much influenced by public opinion at the time, which is these crime rates are getting out of control, we need to lock these people up. And the effect of that was so-called mass incarceration, which is one of the great shames of this country, where we have, as I'm sure everyone here knows, we have over 2 million people in our prisons and jails, which is considerably greater than any other country in the world, both in percentage terms and absolute terms. And even though crime rates have gone steadily down essentially every year since 1996, the number of people in prison has stayed pretty much the same or even gone up for part of that period because we're locking up an ever higher percentage of people for ever longer periods of time. Most of those people are young Black and Hispanic males. That's 60% of them. A great many of them are in prison for nonviolent crimes. It's a disastrous situation. It was only, even though the crime rates were going way, way down, it was only in the last few years that there developed a public opinion that was unfavorable to the policies that had led to all those people being locked up. And even now, it's by no means a consensus. So, for example, it was in a policy that began in the Clinton years, was continued through the Bush years, it was continued till the last 2 years of the Obama administration. Every assistant U.S. attorney in the United States was ordered to charge in the indictment the most serious crime you could possibly prove. And that created then this incentive to plea bargain. That was the justification for it. But it was part of this whole syndrome. Partly because of the recognition of the evils of mass incarceration, the Obama administration in the last 2 years did away with that. Attorney General Sessions has just reinstated that in the past week. And that's once again the policy of the Department of Justice. So I think it will be a while before you see enough public opinion to have the kind of force that Professor Grunfest was talking about. And it's a shame because it is the prosecutors who really control the criminal justice system. Yes, ma'am.
I have just a question. I don't know if it's appropriate here, but so talking about the increase in people that are in jail, to what extent would you say that the privatization of jails has kept that number high? And then is there a requirement that prosecutors and judges can't have investments in those types of businesses?
So I have no idea the answer to the second question. I'm a poor barefoot judge. I can't afford to invest in anything. Yeah, but the answer to the first question is there's a school of thought that says that there's now a lobby in the form of the companies that provide private prisons that lobbies Congress to continue to keep these laws. I think that's a factor, but I don't think it's a major factor. There are very substantial people. I'll give you an example. The Koch brothers have come out very much in favor of decriminalization. So there are meaningful economic forces arraigned on the other side as well. So it may be true, but I don't think it's the primary factor. Yes, ma'am.
So I know you've written about the delegation of judicial authority to administrative courts. What are your thoughts on the recent constitutional challenges to SEC administrative proceedings?
Well, I don't want to comment on that because it's still pending and we're forbidden for talking about any pending case, not just before ourselves, but before any judge. But I will point out two aspects of that. First of all, just so you're all aware, what you get in the way of a judicial proceeding in an administrative court, not just the SEC's administrative court, but most administrative courts, is something totally different from what you get in a regular court of law. So if you are, first of all, the judges, some of whom are very good, I don't want to imply otherwise, but the judges are appointed by the regulatory agency, they're paid by the regulatory agency, they have a term, and they have to be reappointed if they want to continue, and so they have a built-in, if you will, incentive not to be too much at odds with the administrative agency. Furthermore, they have narrow vision because they're operating in a very specific context. Many of the securities laws, for example, are used criminally, are used privately, and are used regulatorily, but the administrative law judges only see them in the regulatory context, so they may give them what I would consider a skewed interpretation because it makes sense in that context, but it doesn't make sense in the broader context. Just to take the most obvious example of that, judges are instructed that civil statutes should be broadly construed to achieve their remedial purposes, but criminal statutes should be narrowly construed to protect the innocent and provide fair notice. A rule like 10b-5 of the Securities Exchange Act is enforceable both civilly and criminally. A federal judge who gets a 10b-5 case is aware of that, so they know they have to balance the interpretation. They want to make it right so it'll work for the criminal and for the civil, and that's a difficult job. A regulatory judge who gets the same case only looks at it from the regulatory standpoint, so they will typically give it a broader interpretation, which will then, because of the Chevron decision, carry over to the criminal side as well. You have very limited discovery in most regulatory agencies. You have tight time deadlines. You have very limited motion practice. And you, of course, don't have a right to a jury. So there are a lot of things that you don't have in the regulatory context that you do have in a regular court. And that, to me, is the least problematic. My brother, who teaches administrative law at some other law school called Harvard, so he must be smart, right? Says, well, would you want to have in federal court all those Social Security cases? What he didn't know is we do. We're stuck with them. Yeah, there are kinds of cases, obviously, you just as soon have regulatory judges deal with. The statistics are this. The SEC wins over 90% of its cases in its own courts and wins only 65% of its cases in federal courts. So I think that shows it's a different forum in practical terms. Here, we've got the
data. We've got the data. You're relying on the Wall Street Journal.
That's true.
Okay. So Kristen Savell and I wound up looking at a full year's worth of data, and it turns out that if you separate out insider trading cases, where the SEC's record is miserable, both in administrative and in federal cases, and if you do the counting correctly, for example, counting a summary judgment victory as a victory, it's even better than a victory because you win without, so you go do the numbers in a certain sense right, not the way the Wall Street Journal did it. It turns out that the SEC's success rate in federal court over a one-year period, which is relatively short, was about 96%.
Wow.
And its success rate, 97%, and its success rate in administrative proceedings was 96%. So if you wind up taking the SEC fully to verdict, all right, or to summary judgment, you're likely to lose. Okay? If you're foolish enough to take it that far, except in an insider trading case, you're likely to lose. A professor now at Georgetown did the similar analysis but for a larger data set for a 3-year period, and she found essentially the same numbers, 94, 95%. And again, insider trading cases, they're the most notorious, but they're the least typical.
All right. Well, that's extremely interesting, and I've learned from long experience that as between the Wall Street Journal, which is what I was relying on, and Professor Grunfest, it's no contest. But
My subscription rates are cheaper.
However, I'm interested in those statistics for a different reason, because that suggests that the SEC always wins in each forum, which I love the SEC. They're a great agency, but no one's that good. I wonder what's going on there that they're winning all the time.
The problem is they bring crappy cases and they settle for nothing.
All
right? Or they wind up costing your clients millions of dollars in investigation costs. They send you a Wells notice, and at the 11th hour, when they're first put to the test, they go, never mind.
Okay, so
that's what's happening.
So that's interesting too. All of which suggests something less than what would ideally we would like to go on in an adversary system. So what he is, what Professor Grunfest is saying, if I understand it, is they win cases by saying, okay, we'll settle it now for 2 cents. And you must, I'll have an injunction. You must never, ever, ever do it again. Or they bring the harder case and then they withdraw the case. Is that essentially what you're saying?
Yeah.
Okay. Yes.
This is why you see a lot of the cheap settlements, Your Honor. It's because they got a lousy case, and they won't just look at it.
In any event, going back to the original point, well, I have no idea as to how those cases that have been brought challenging the constitutionality of all this should come out. What I think is fair to say is that these administrative cases are not operating in the way we would like to see cases operate, apparently in either form. So, yes.
This is building off what Professor Griffiths just spoke to, but with the different pleading standards or higher pleading standards that we've seen, and also going back further, the higher standards to get past summary judgment, how do you think that impacts the ability of the government or even private plaintiffs to get a remedy that perhaps we as a society would like to see or that might be appropriate?
So the higher standards are mostly for private plaintiffs, not for the SEC. I don't think there's been a significant change in the standard required of the SEC for at least the last 20 years or so, but there's been plenty of changes through the Private Securities Litigation Reform Act and other acts making it much harder to bring class actions and requiring higher levels of particularity, higher levels of intent, and so forth. So what's going on in that context is that many of those cases were perceived, rightly or wrongly, to be extortionate. So you basically didn't see modern class actions till 1966. And Rule 23 of the Federal Rules of Civil Procedure was amended in 1966 to allow damages actions to a much greater extent. Previously, most class actions have been primarily actions for injunctive relief, and they serve wonderful purposes, like in the civil rights movement, where you would go into, you wanted to have an injunction that this restaurant could not bar any African American from entering and sitting down at the lunch table. Before class actions, if the government had not intervened, you could bring an action for yourself. I was deprived of the ability to sit at that lunch table, and you can get an injunction, you must submit that person. But it was only through the class action injunctive device that you could get this order saying all African Americans must be admitted to that. So that was great. In 1966, the rules were amended, the class action rules, to make it much easier to bring actions for damages. And while that was focused, again, on civil rights and other actions of that kind, it was quickly picked up first in antitrust actions and then in securities actions, and those became the more common class actions. And some of those actions were perceived to be extortionate for the following reason. If the pleading standard was low, which it was for most civil actions back in those days, you could bring an action in which you alleged, my client, the investor, lost $200 because of an alleged fraudulent statement that was made before he purchased the stock. And he's a class of 1 million purchasers, so we're seeking damages of $200 million. And the lawyer for the defendant might say to his client, hey, we think this is a totally baloney lawsuit. No one can absolutely ever say for sure that we're going to win, but maybe there's at most a 2% chance that the plaintiff will win. Then a rational business person would say, okay, so I should settle this case now for $4 million, 2% of $200 million if I get my arithmetic right, and this guy will go away, and I won't have to go through all the expense of a long and difficult litigation. So those were perceived, and to the extent that scenario is true, I think it was an extortion situation. So Congress and the courts as well, both the Supreme Court and Congress played a role in this, and they steadily increased the pleading standard for those kind of actions. Some people think they went too far in that direction because the complaint is brought before there's any discovery. So unless you're a tag-along action to facts that have already been developed by the SEC, it's going to take an awful lot of effort, time, and often ingenuity to be able to develop. And you'll see complaints typically today where they're not tag-along actions will refer the complaint to information from confidential employees who were willing to be whistleblowers or the like. So the pendulum may have gone too far. I have views on that, but I'm not comfortable expressing them. But I think it's been much more on the private class action side. I don't think it's particularly impacted the SEC.
Sorry if you all have more questions, but I think we need to wrap this up. I want to thank you all for coming, and a big thanks to Judge Rakoff.
Well, thank you.